The trial court erred in precluding Mr. Peterson from presenting relevant mitigating evidence, which could have served as a basis for a sentence less than death. After the jury returned a guilty verdict, the matter went into penalty phase. As part of the mitigation case, defence counsel offered testimony from retired Orange County Superior Court Judge Donald McCartan. Out of the jury's presence, the defence made an offer of proof that McCartan had presided over 15 death penalty cases and sentenced 9 defendants to death. Defence counsel initially offered to present Judge McCartan's opinion that death was not the appropriate sentence in this case. Judge McCartan would, if called, testify that based upon his examination of this particular factual situation and the lack of record of my client and the nature and circumstances of the crime, that in his opinion my client does not qualify for a death penalty imposition of the death penalty number 1. Number 2, that he certainly is not among the worst of the worst that he has seen, and that this is not a case that where the death penalty should be imposed. The state objected to this opinion evidence. The court sustained the objection. The court advised defence counsel that he was free to argue that your client is not the worst of the worst, and he could compare him to other cases without talking about specific deposition of those causes. But Judge McCartan's opinion is totally irrelevant. Counsel then asked why he was precluded from producing evidence on a point which the court said he could argue. The court responded that you can produce evidence, you can't do it through Judge McCartan's opinion. It's totally irrelevant. Given the court's ruling that Judge McCartan's opinion was irrelevant, defence counsel shifted gears. He then offered the judge as a fact witness to testify about various types of cases where death had been imposed. Although this was no longer opinion evidence, the trial court ruled this fact-based evidence inadmissible as well. No. Answer is no. Totally irrelevant, okay? So don't mention Judge McCartan. Defence counsel made clear he understood that under the court's ruling, Judge McCartan can't come in and opine as to a legal conclusion. But counsel emphasised that in light of the court's ruling he was revising his proffer and was now asking that Judge McCartan be permitted to come in and compare or testify as to the facts of other capital cases. The court excluded the evidence. No, can't do that, but you can certainly argue it. Mr. Peterson here has no quibble with the trial court's initial ruling, excluding Judge McCartan's opinion as to whether death was a proper sentence in this case. But the trial court's next ruling, precluding defence counsel from presenting evidence of cases in which death was imposed, violated the 8th Amendment. The United States Supreme Court had broadly defined mitigation as any evidence which might serve as a basis for a sentence less than death, or which a fact finder could reasonably deem to have mitigating value. As courts and legislators around the country have all recognised, the evidence proffered in this case met both these definitions. The trial court here was not free to simply ignore the pronouncements of the United States Supreme Court. A new penalty phase is required.